So starting with the 5-day written notice of non-payment in the lease agreement, this is covered in section 27-40-710B of the Residential Landlord and Tenant Act. If the landlord provides the 5-day written notice in the lease agreement, the statute does include language that would be considered proper language for a 5-day written notice of non-payment in a lease agreement that I've copied and pasted onto the slide for you to view. It says, if you do not pay your rent on time, all caps, this is your notice. If you do not pay your rent within 5 days of the due date, the landlord can start to have you evicted. You will get no other notice as long as you live in this rental unit. Like I said before, if the landlord includes this language verbatim in the lease agreement, this satisfies the notice requirement for a 5-day written notice of non-payment in the lease agreement. Please keep in mind, though, that if the language in the lease agreement is not exactly how you see it on the screen now, and it's not word for word what I've copied and pasted on the slide, it can still be considered proper notice. The statute requires that it at least be substantially equivalent to this language, if not verbatim what you see on the screen. And if the landlord includes this language in the lease agreement, the landlord is not required to give a separate written notice to the tenant in order to satisfy the notice requirement in the statute. It's also important to note that the language in the lease agreement needs to be conspicuous. It needs to be clear. It needs to stand out. It cannot blend in with the rest of the language in the lease agreement. Examples, as you can see with the statutory language I've copied and pasted on the slide, if you do not pay your rent on time is in all caps. Another example would be if it was in bold, underlined, all caps, all three, or just one. Any way that it could be arguably conspicuous and stand out to you in the lease agreement would be considered, that would be a requirement. And if it meets all the requirements on the slide, then it would be considered proper notice. 5-day written notice of non-payment in a separate writing. This is also covered under section 27-40-710B of the Residential Landlord and Tenant Act. The statute requires that this notice be in writing, that it notifies the tenant that they are behind in their rent, that it states that it gives at least 5 days from the date in the notice for the tenant to pay the past due rent, and the landlord's intent to terminate the lease agreement if rent is not paid within that period. Now, to address the question about the notice, the 5-day notice being in an email, of course, I don't know specifics as far as what's contained in it. The statute just has the following requirements. With technology and everything advancing, I don't particularly see why it would be considered improper solely for it being in an email, but as long as it has the statutory requirements, it could be argued that it's proper notice, as long as it meets the requirements that you see on the screen. Just keep in mind that your situation could be different depending on what your lease agreement says. A lease agreement could give you a lot more time than what's required by the statute. So it's just important to thoroughly read your lease agreement to understand what your options are, because you may get more than 5 days depending on what's in your lease agreement. What the landlord cannot do is subtract from the 5 days and say you only get 1 day or 2 days, or if you're immediately behind, I'm filing an action. I mean, that's not considered proper. So it just really depends on what your lease says. Read that thoroughly and understand that your situation may be a little bit different depending on what's in your lease agreement, as long as it does not directly conflict with the statute.